one of us will get something out of your knowledge, expertise, and experience. And this session is intended to be very collaborative and interactive section. I would urge our participants to engage with the resource speakers, ask as many questions as possible so that we get maximum from our resource speaker. And I guess I have to give more time to Doctor to speak because he is the specialist. I am looking forward to hearing from you, again something out of your expertise, knowledge, and experiences. I wish all the participants a very fruitful, engaging, and interesting webinar. Thank you, everyone.
So, shall I start now?
Yeah, I think so. I think something is wrong.
Mr. Sakib?
Yeah, he appeared to be, I mean.
Okay, so
some
gradually I start and you will join in between. I think that would be better.
Actually, Shakib, what happened?
Sir, can you hear me? I don't know, maybe there's just an internet issue.
Something wrong. Okay. Okay.
Yeah. Okay, so I think now it's better. Sir, I'll just take a little bit of time to introduce you properly, and then maybe I'll invite you to start. So, although Dr. Adhikari needs no introduction, especially in the Nepali legal circle, however, for guests who are joining from around the SAARC region, I'll just take a little bit of your time. So Dr. Rajendra Prasad Adhikari is a distinguished Nepali professional with extensive experience in procurement, contract management, and dispute resolution. With a PhD in management and multiple advanced degrees in law, political science, and engineering, Dr. Adhikari has served in various capacities, including as a procurement specialist for major projects funded by the World Bank and the Asian Development Bank. He is also an accomplished academic, having held faculty positions at prestigious institutions in Nepal and supervised numerous MSc and PhD theses. Dr. Adhikari is also a registered advocate as well as the current chairperson of NEPCA and is regularly involved as an arbitrator in numerous disputes. His expertise and leadership is in both the academic and professional arenas make him a highly respected figure in Nepal's legal and engineering communities. SARCO has been very lucky to have worked with NEPCA on a number of occasions, especially with Dr. Adhikari, and I'm hopeful that today's session will be also one of our most productive sessions. So, Dr. Adhikari, thank you once again for being part of today's webinar, and now I'd like to invite you to take the floor.
Thank you very much, Sakib-ji, for a very nice introduction. So, for your kind and generic introduction. Director General SARCO, Choning Dorji, for your kind forewords. Thank you very much. Distinguished colleagues and friends, this is really an honor for me as well as for NEPCA to share some of my perspectives on ADR, this alternative or appropriate to dispute resolution to this webinar or through this webinar. And thank you again. Before entering, let me share this slide, and that makes easy. Could you allow me to share the slide, Sakib-ji?
Yes, sir. I will allow you, sir. Yeah.
Just a minute, I get it. Okay. So today's topic is capacity building. This is my focus on basically the capacity building for legal, professional, and arbitrators. The topic is emerging ADR laws and practices in South Asia. So the objective of this webinar is to build skills for ADR professionals in South Asia. to explore emerging ADR laws and practices, to share comparative insights from global frameworks, to encourage regional cooperation and harmonization. So this is the broad general objective of this webinar. So I would like to focus on these aspects, but not being very specific. In general, in generic way, I will try to shed lights on these things so that in conclusion of this my presentation, there will be good discussions with the specific country context as well as from the various practitioners' perspective. So I expect for that. The contents that I will be covering today is Nepal and NEPCA in terms of ADR. Briefly, I will touch on that part. Then why ADR and ADR landscape, along with early history and history of this ADR mechanism, ADR environment and practices, particularly referring to, generally referring to our context, and finally a conclusion about the presentation so that our discussions will be more focused on towards the matters that we discuss through or in this webinar. And this is the age of technology, and we have to work with, for ODR as well as to work with AI. So while developing a framework for this presentation, I also worked with Copilot. So I acknowledge, with your permission, the contribution of the Copilot as an AI assistant. So let me start the presentation briefly about Nepal landscape. Nepal is practicing arbitration for over 6 decades with formal recognition from the state. So in 1956, Development Board Act was enacted in Nepal, and that has recognized, acknowledged the arbitration for resolution of disputes as an alternative mechanism. So that was the formal beginning of arbitration or recognizing alternative dispute resolution in the Nepalese context. And thereby, Arbitration Act enacted in 1981, this was the first comprehensive act for arbitration that has recognized and that has gathered all required essential elements for recognizing ADR and putting into practice. Then followed by Arbitration Act in 1999. This is what the prevailing act in Nepal. So this replaced the Arbitration Act of 1981. And we do have Mediation Act 2011 also. So we have two separate acts that has recognized alternative dispute resolution as a mechanism for resolution of dispute outside the court. And the major thing that it has made, arbitration or this dispute resolution as an integral part of contract agreement between parties. So even if there is nothing mentioned in contract agreement about the dispute resolution or arbitration, is there any noise? Okay, I will continue. And even though if there is no contract agreement, nothing mentioned in the contract agreement about the dispute resolution process, then also through this Arbitration Act 1999, so arbitration procedure can be followed by the parties. So this is one very important backup provided by the arbitration law. Similarly, the other important thing in Nepalese legal judicially thing is that the Constitution of Nepal, this is the new, we call it New Constitution 2015, it has recognized mediation and arbitration as an alternative means for settlement of disputes. So it has incorporated in its policy relating to justice and penal system. So this is a very important provision in Nepal backed up by the Constitution for ADR. And because of that it is recognized by the Constitution, it has also imposed the duty on the arbitration that is to act independently and impartially in delivering arbitral award. I think this is a very big challenge for any arbitrators practicing in Nepal, because the constitution has demanded independency and impartiality on the part of the arbitrator. Definitely, it demands for quality of arbitrator. So practicing being as an arbitrator is very much a very responsible job. So this is the thing what we have to, I would like to put before you. Definitely, Nepal is also a signatory of New York Convention 1958. We'll discuss afterward also. And the features of Arbitration Act 1999, I will not describe it in detail because there are other things to share with you. Just briefly, this has been a governing law, and dispute has to be settled through arbitration. And the important thing is that the appointment of arbitrator by the court, it has provision that if party could not appoint arbitrator, or if any party failed to appoint arbitrator, then High Court will act as appointing authority. And NEPCA is also doing this job, acting as appointing authority if the NEPCA rules has been incorporated in the contract agreement, or the parties agree on NEPCA will act as appointing authority. So this has been our regular task to appoint arbitrators in the dispute. And oath, again, is needed by the arbitrators for fairness, impartiality, and honesty. That part is there. And the arbitrators, before the start of proceeding, they will sign the oath. And this signed oath, copy of signed oath, the original copy will go to the court. That has to be sent to the courts. And recently, in 2025, fast-track arbitration provision has also been incorporated by amendment in the Arbitration Act. And other thing to note is that the arbitrator can determine their own jurisdiction. So this is also important provision. I think most of the all SAARC nations do have Arbitration Act. I hope so. And these are the general features on the Arbitration Act. So there certain power has given to the arbitrator. For example, directing the concerned parties to appear before the arbitrator or submit the documents and record the statements, or appointing expert and seeking outside opinion. So some of them, these are among them now. So this has been another important part. And court assistance in evidence verification. This is another important part in Nepalese Arbitration Act, that the court assistance can be taken by the arbitrator if so required. And the duration for arbitral decision is, in general, it's 120 days from the date of submission of the documents. So there is a timeline for delivering award, and court may enforce the decision. This is very important for international arbitration as well as for domestic arbitration. So these are the timelines incorporated or provision in the Act. Now let's go on the brief about NEPCA. So in the background legal environment, NEPCA established in 1991 as an autonomous and non-for-profit organization, just to administer, to facilitate this ADR purpose, particularly the arbitration. And this is the leading and the oldest institution in the country administering and facilitating dispute resolution. There are a few other institutions are coming up, and they are also engaging also in resolution of dispute part of a thing. But NEPCA is the oldest and leading, and it administers arbitration and adjudication. And we have published adjudication rules, NEPCA adjudication rules, NEPCA arbitration rules are there. And NEPCA Code of Ethics, the another important part to regulate the arbitrator rather than controlling, to regulate arbitrator. We have drafted Code of Ethics for arbitrator based on Nepali practices. And we are publishing half-yearly publication as NEPCA Insight. So this is what we are regularly doing to share experiences and knowledge. And taking this opportunity, I would like to request you to contribute for NEPCA Insights if you wish to write some articles. So we'll be happy to have your articles on NEPCA Insight. And we conduct trainings, monthly webinars, 29 regular webinar that we have already concluded, and a conference and seminar type of thing that we do. And recently in 2025, again, we convened one national conference on arbitration for effective dispute resolution, and we published one proceeding of that also. So this is how NEPCA is working. And so far as NEPCA strength is concerned, right now we have 70 general member and 329 life member with NEPCA. It's almost 400 members strength is there. And among them, again, we scrutinize based on the application from our life member to be enlisted as an arbitrator. So there is another stringent criteria to become arbitrator. And so far there are 74 arbitrators, they have been enlisted as arbitrator. So this is general background about what the legal environment related to ADR in Nepal, as well as what NEPCA is doing. So now let's enter to the main purpose and main theme of the main presentation. Why ADR? So mostly we all know that. Why ADR, alternative dispute resolution? Because there are court backlogs and delays. There are many backlogs and delays to facilitate resolving commercial type of disputes outside the court and to provide a legal remedy to avoid delayed justice. So this type of thing is there. Therefore, the ADR has been very much gain importance, and this is being practice. If we see the data, there is population. Definitely, the size of the population matters in having backlogs in the court proceedings. And I didn't get the data from Afghanistan, and Bhutan and Maldives are better, except they have very few backlog cases in their court. Bhutan and Maldives, the data is there. Besides that, all other SAARC regional countries do have many disputes. They are waiting for court decision. So you can see the numbers in these slides. So how this can be facilitated? How this can be used? Means we need to have this alternative dispute resolution mechanism, because they pay trade, because they pay commercial activity and economic activities just it's compared with their profit and benefits, and for this they could not wait for longer period, so they need quick decision on these matters related to their disputes. So this has been gain importance. The ADR has gained importance because of to ease the backlog of the courts. Similarly, the cross-border trade and investment dispute has been increased along with this liberalization of the economy and existence of multinational and cross-border trades. So this has been the reality of any economically developed countries these days. So if we see the developed countries' experiences and examples, the dispute cross-border also in a rise. So because of this, because of cross-border trade and investment disputes, the ADR is becoming important. And because of this, the parties involved in cross-border trade and the different jurisdictions require trustworthy, cost-effective, and speedy dispute resolution in their matter of disputes. So these are general background why we need, or why this ADR has gained importance in these days. And we all know, we all are aware that ADR refers to various mechanisms adopted for resolution of disputes, such as conciliation, mediation, and arbitration in general. And we will see the act referring to, related to mediation and arbitration in most of the jurisdiction. So this is the major thing why what is the ADR. And if we talk about construction disputes, there are various other mechanisms that we practice as ADR. For example, certification, valuation, engineer's determination, or project manager's decision, adjudication, DB, DAB, DAAB, DAB, and arbitration, including conciliation and mediation. Now we are also talking about made type of thing. So these are the various alternatives that are available, that are being practiced as ADR in this type of resolution of dispute outside the court. And all our societies, but is this the new thing? Is this the new concept? Definitely no. All our societies have practiced alternative means for dispute resolution from the ancient times. If we look at the history of each of our societies, even before introduction of the formal governing procedure, this ADR were practiced at community level. So basically, this is not the new concept. However, gradually with the increase in economic and commercial activities, just we discussed, commercial activities, formal ADR mechanism that became essential. And with increase in cross-border commercial business activities, particularly formalization of international arbitration gained importance. So this is how this thing has been growing up. And if we trace the early history, when was it started? It is said that the first referred agreement, arbitration agreement, was of the 1224, because of the merchants travel to different towns and fairs needed expedited decisions on commercial and contractual disputes. So see, the economic activities play a very important role in development of, in progress of any societies, any communities, and any countries. So because of that, it became essential, and the different traders or these fairs, person doing fairs, this type of activities need a commercial and contractual dispute resolution mechanism as an alternative. So far as legislative attempts is concerned, it is said that Bengal Regulation of 1772 was there, and it is revised, amended, and renamed in 1780 and 1781. So the history trace, it comes linked with long past. This is not a new concept. So it has been built up with this and refined along with the need of the time. And we know, we are very much aware of the ICC, and this ICC, even ICC arbitration rule were said to have been first published in 1922. So almost 100 plus years that it has crossed. So we have long history of practicing arbitration and just working with the arbitration rules. And this was even before the establishment of International Court of Arbitration, which was just following year it was established. And that was the early history, what I said. Now, if we look at the history, which we may talk about New York Convention, and let's see the history of New York Convention 1923 to 1958. So there was Geneva Protocol on Arbitration. It was established in 1923. Similarly, the Geneva Convention on the Execution of Foreign Arbitral Awards was there in 1927. So for this, there was dissatisfaction, or this was not adequate to address the need of that time. Therefore, the ICC took the initiative to replace the Geneva treaties, came from this, and it issued a preliminary draft convention in 1953. So it was initiated by the ICC in 1953. And this initiative was taken over by the United Nations Economic and Social Council, which produced an amended draft convention in 1955. And this draft was discussed during a conference at the UN headquarters during May-June 1958, which led to the establishment of the popular New York Convention, which we refer these days. We talk more about this New York Convention 1958. So if we look at the objective of New York Convention, what was the objective? So recognizing the growing importance of international arbitration, see the need of the time, responding to the need of the time, responding to the need of economic activities. As a means of settling international commercial disputes, the Convention seeks to provide common legislative standards for the recognition and enforcement of foreign and non-domestic arbitral awards. Definitely, this is about execution, implementation of the international or non-domestic arbitral awards. And the principal aim of this was the foreign and non-domestic arbitral awards will not be discriminated against, and it obliges parties to ensure such awards are recognized and generally capable of enforcement in their jurisdiction in the same way as domestic awards. So this is a very strong foundation of New York Convention. And the other aim was to require courts. See, this is a very important sentence that I feel. The ancillary aim of New York Convention is to require courts to deny the parties access to court in contravention of their agreement, because it is to refer the matter to an arbitral tribunal. So this is a very strong backup provided by New York Convention for strengthening ADR, particularly the enforcement of arbitration, that is the decision awarded in any foreign jurisdiction, not in the domestic jurisdiction. So this is very important in implementation, in effectiveness of foreign or international arbitration. So if we look at the ADR landscape, international and regional, we need to talk about London Court of International Arbitration. It has tremendous contribution in strengthening, in popularizing, and in refining arbitration procedure all over. So it was formally inaugurated in November 1892 as the City of London Chamber of Arbitration. So all these provide lessons for us, I think, that we should be proactive to change, to transform ourselves as per the requirement and need of the time. Otherwise, we will not play that much influencing role in this arena. So why LCIA is must and more influential? Because it has started as the City of London Chamber of Arbitration, and in April 1903, it renamed as London Court of Arbitration, and subsequently, in 1981, renamed as London Court of International Arbitration. So it has been transformed itself, and continuously working, continuously putting hard effort, and continuous updating is essential. It shows that. And similarly with ICC, the first ICC rule was published in 1929, and continuously it is refining, and it is working in this field. Even before which I just before also mentioned, the establishment of International Court of Arbitration. Then there is another leading arbitration institution. We called it AAA, American Arbitration Association. It was founded in 1926. Similarly, and UNCITRAL model law came into existence, and it influenced highly to many countries to frame, to form, to draft their Arbitration Act. So it was model law of international arbitration was in 1985. It is there. These are some institutions contributing internationally to the ADR field and in arbitration. And let's see, in our region, Asia region, the Hong Kong International Arbitration Center, it was established in 1985. It is coming up, and it is what to say? It is being popularized these days. So still, it is putting effort to become more prominent. Singapore International Arbitration Center. This is the relatively newer institution, came up and is a very much influential and very much leading in our region these days. So, and even the dispute resolution, arbitration, or ADR mechanism is contributing to GDP of Singapore economy. See the dispute resolution activity, how this can play a pivotal role in development of any country, for economic development of the country. This is what we need to realize. Particularly, it is not that we who are here, it is the government, it is the public institutions that need to realize this type of thing for development of our economy and development of our country. Similarly, Dubai International Arbitration Center, it was established in 1994. Now it is coming and it is what to say. It is in the scene these days, along with the economic activities and development of the vibrant economy with this EU-EAE. So these are the things that how the country's economic development or how the credible arbitration and quality arbitration environment contribute to the economic development of the country. For this, again, to strengthen, to again reframe this idea, I've taken an example from China. No, this is another economically influencing nation these days. And what is the situation of China and how it has responded to the ADR mechanism in China? This may be of interest and curiosity for us. So let's see. The Foreign Trade Arbitration Commission was formed in May 1954 in China. Then it is renamed as Foreign Economic and Trade Arbitration Commission in 1980. And thereby it became CITEC, China International Economic and Trade Arbitration Commission in 1988. And see the other interesting thing, since 2000, CITEC is also known as the Arbitration Court of the China Chamber of International Commerce. So when I just compare with our institution, for example, like NEPCA, where I am working, we have difficulty in transforming ourselves. We are facing difficulty in changing ourselves. We are facing difficulty in becoming proactive in delivering this type of services. And this is some sort of anomaly, along with whether the government facilitation and other things will help achieving this thing, or the proactiveness of the this dispute resolution leaders of the particular country and the region. This is what we need to discuss in our floor and forum like this. But let's say a little bit about this China example. So the data showed that in China, There are 285 arbitration institutions and over 60,000 arbitrators, and including more than 3,400 overseas arbitrators. See the size of the economy and size of the dispute resolution institutions and the practitioners. So I think this is very interesting to note and to think over this. And I also request you to just analyze and explore by yourself what are these things and what they just give the lessons for us to learn. In 2024, a total of 4,373 foreign-related arbitration cases were handled nationwide. So this shows the other dimension of dispute and dispute resolution. As a globally recognized mechanism for resolving commercial disputes, arbitration plays a vital role in national economic development. Time and again that I have been repeating this thing with you. China has been running a pilot program since 2022, aimed at establishing international commercial arbitration centers in 5 regions, Beijing, Shanghai, Guangzhou, Shenzhen, and Henan, which has yielded significant process. NEPCA has also signed MOU with Guangzhou, and Guangzhou is considered as the 8th largest economic hub in the world. See the linkage, see the relationship between economic activities, the size of foreign direct investment, and the associated dispute and dispute resolution climate. The credible climate for resolution of dispute that will help making vibrate, making operationalize the particular economy of the country. This is what I think the message of such examples will provide. Now let's again come back to the ADR environment and practices with all this overall general background. So if we talk about ADR environment and practices, we can just limit it and concise this concept into the legal framework. Effectiveness we can talk about in terms of time, cost, and quality, and the role of the respective court, and the capacity development part is there, and the enforcement of arbitral award. That is again maybe associated with the role of court, but this is a different thing. The understanding of the respective country's government is essential, plays very important role in enforcement of arbitral award. So this I will briefly discuss on this point. Excuse me. Now let's talk about legal framework. So while I just browsed through the internet, we saw almost all we do have adequate legal framework. So legal framework is there. Sorry. And this is what I already tossed Nepal example while presenting Nepal arbitration landscape. So I will skip this slide, Nepal, for example. This is just to show you as an example. But the laws in our respective jurisdiction may require timely updating. So this is very much lacking in our region and in our part. Particularly, we are realizing this in Nepal context. And the other thing is that though there are laws, adequate laws, but the effective enforcement of the law, the spirit of implementation of the spirit of the law, practice as per the spirit of the law may be lacking. So the effectiveness may be, in many instances, it is under the questions. So this thing, what we need to consider. And let's talk about the effectiveness. So because the time effectiveness is the major thing, which can be just compared with the time, cost, and quality. So there is one study conducted with the NEPCA's NEPCA administered disputes. There was a study conducted by our team, and average duration for conclusion of arbitration is found as 400 12 days. It is quite a long duration. So in terms of time, we must accept that it has not been that much effective. However, there are very few cases, 1 or 2 cases that in 165 days that arbitration has been concluded, but that were the because of the parties settled amicably after referring this matter to the arbitration. So in terms of time, we need to explore, we need to see whether we have been that much effective to deliver award and arbitral decision or not. So this part is there. And the reasons for delay, while we analyzed them, this is revealed that particularly because of the delay in payment, basically by the respondent side. The claimant deposit their portion of the fee, and the respondent do not deposit. It means not supporting, not facilitating in fact, not cooperating with the arbitral procedure. So this shows the mind of the particularly public entity or the respondent. So this will hamper the economic activity, and this will hamper the other investment type of thing. So this is there. This is the Nepal case, and due to the parties' behavior, they may postpone because of citing different regions. So that's 11%, and other regions, the administrative other regions are there, about 18% is there. So basically, the delay in payment. And the cost these days, in all countries, what I would like to say, even in developing countries, the cost of arbitration is said that has become expensive. So this matter need to be reviewed or discussed within the institutions like NEPCA and other regional institutions in the respective countries, and in the international institutions like SAARC and London LIAC, or many other institutions. So this part is the cost. And the other one, major and very important thing for aspiring arbitrators and legal practitioners who would like to enter in this area of alternative dispute resolution, the quality of the decision, the quality, it matters a lot. So let's talk about the incidents related to the quality of arbitration. The Singapore Court of Appeal. So this was recently came out. The Singapore Court of Appeal has set aside an international arbitral award issued by a tribunal chaired by former Chief Justice. After concluding that, nearly half of the award was directly copied and pasted from previous cases. So this is the time of technology. This is the time of AI and digital platform. So this has made the arbitrator, this has made the legal practitioner or other practitioners working in this ADR field more vulnerable along with the introduction and use of technology. I just mentioned you that I have assisted by I took assistance from Copilot. So now need to be aware. And the integrity and the quality of arbitrator will be in questions, very much in question. So I would like to say that it is not as easy as we have practiced some 15 years back. Now, this part is there. So this is very much challenging. And the arbitrators had delivered the decision with a closed mind. See, this is the court concluded without independently considering the facts and submission in the present case. So these are the things taken into consideration by us, by all of us. It is not the any who is experienced practitioner or who is aspiring to enter in this profession in this area. So all we need to be very serious about this. Now let's talk about the role of the court. In terms of the role of the court, we all know that court plays very crucial, critically important role in defining, clarifying, and streamlining the arbitral procedure in any jurisdiction. So this requires court understanding on ADR mechanism. Only that help creating reliable and credible ADR environment. For example, this is also a case from India. This is a very well-known case. It was referred to High Court of Kerala after Arbitrators' decision, and finally it was taken to the Supreme Court of India. In this particular case, the Supreme Court cited the decision of Sukanya holding case and said that the consent of the parties is not necessary to argue for a case reference to arbitration. So without consent of the parties, the case can be referred to arbitration. This is what the court clarified. And the Supreme Court has assumed that even in the absence of an arbitration agreement, the civil court to submit a case to arbitration. It allowed, even in the absence of an arbitration agreement, the parties may choose to use alternative dispute resolution ADR with mutual consent. So some sort of ruling by the Supreme Court, and this stabilizes, this provide a very good base, very good backup for practicing ADR mechanism, particularly the arbitration outside the court. And there is another, this is, I think these are important as a reference. The chloro controls decision is also there. So there was a dispute arose between joint venture from joint venture agreement between several country companies, some of which were not direct signatories to the arbitration clause. Many times while sitting for arbitration, we may come up confronted with this type of issues. So a domestic party objected to arbitration proceedings initiated by foreign parties. And then see, the legal issues involved in this case was, can non-signatories be compelled to arbitrate? Does Part 2 of the Arbitration and Conciliation Act 1996 of India apply to international commercial arbitrators, where not all parties are signatories? And what is the scope of this Section 44, that is the enforcement of foreign arbitral awards? Now, the contribution of this decision was that has a broader scope than Section 8, which governs this is there. This recognized group company doctrine in Indian arbitration law and made Indian arbitration law more responsive to commercial realities involving complex corporate structure. And the impact of this decision was this judgment made it easier to conduct arbitration in multi-party contracts. See the court role and court facilitation. And it aligned Indian jurisprudence with global best practices. This is what we also need now from respective courts that help streamlining and setting best practices in ADR mechanism so that it will contribute to the court practices as well as promoting the justice through ADR mechanism also. And definitely there is criticism associated with this court decision. The criticism was that this decision overextend the arbitration to unwilling parties. It is there, but what the court emphasized is that a careful case-by-case analysis is essential, is required. So this type of thing is there. It has made arbitrator also now with this type of court judgment, court decision, that the arbitrator involved in decision-making should be much more responsible, should know all these criticalities, should know all dimensions like this, but cannot, this is my personal opinion, but cannot exercise this type of authority as the court exercise now. So first, we need to be limit our decisions as following four-corner rule, looking at the contract agreement. And thereafter, this type of court backup and court verdicts will assist the arbitrator to come up with their fair and with good mind to streamline the arbitration practice with a good decision. So there is more complexity and criticality associated with the arbitrator while drafting the arbitration award, while analyzing the arbitral cases referred for arbitration. So this is not that much easy sometimes that as we think, no? So being arbitrator need very careful analysis and very watchful in all these matters. So the decision is considered as a cornerstone for corporate and international arbitration in India, which we also can refer as required, and to gain knowledge how this thing will happen. So in the case of Nepal, there is also one cases I would like to just share here with you. The Department of Road apply in the appellate court against the applied in Supreme Court against the appellate court, and this is the case of 2018, not that much old case. So under the contract, the court defined that under the contract, the government entities are parties related with the government also treated as individual persons, and they will also have to exercise freedom as of an individual person to decide on the subject matter of the contract, consideration, and to agree on the dispute settlement mechanism. So this just court make realize the government entities also that in terms of contract agreement, under the contract agreement signed, they are also be treated as the equal party as of the other party. So they cannot apply their sovereign right. They are not treated as a sovereign body. So this is the major thing. Hence, the dispute settlement shall also be done in accordance with the conditions of contract. So limit yourself within the conditions of contract. So this provides a very stable and a very strong base for ADR mechanism and arbitration. Now I am coming towards the end. So the other thing that in terms of ADR, effective ADR means it requires capacity development. And the capacity development is not only related to a human resource. The first we require is institutional capacity in terms of the institutional strengthening because of respective governments' understanding and support, the legal framework provided, updated, and amended to respond to the need of the time, the court facilitation and support, and modern infrastructure and governance. Definitely, the institutions also need modern infrastructure, which may require additional financial resources. So this is there. And for all this understanding means the presence of governance in the particular economy or the jurisdiction. Definitely, the human resource development part is there. Without human resource development, institution cannot. What is said is that until and unless the individual learn, institution cannot learn. But the institutional learning cannot guarantee, the individual learning, cannot guarantee the institutional learning. So this is a very big thing, how to make an institution a learning institution, learning organization. So this is another paradigm that we need to discuss to make our institutions a learning organizations as of other regional and international institutions. So this type of regional international collaboration play a very important role. And again, I would like to thank to SARCO for creating this platform and again, providing this opportunity to discuss in this matter, particularly for focusing on the jurisdiction of Nepal and focusing to Nepal along with the other practitioners and participants from around the country, outside the country. And the other part is technology. We need to have availability of technology. Sometimes it is very expensive to get all the modern technology. But again, we need this. And just followed by, if there is technology, they need to be familiar, exposure with all this technology. For example, the ODR part is there, online dispute resolution, the use of AI is there, and many digital tools and platforms that we need to use, we need to exploit. This is because this is the time of technology and the digital time of AI, let's say, not other platforms. This is the time of AI. So we need to be versatile and conversant with all these technology and tools. For this, we need all sort of capacity development. So we can discuss on this in the different time and different forums. So other part is if enforcement of arbitral award. So effective enforcement of contract recognized dispute resolution, including arbitration decision, is the essence of effective dispute resolution. So this describes the all thing is there. But the important another thing that I should remind at this time here is that even though the country is a signatory of New York Convention 1958, but reciprocity between the countries again matters in enforcement and recognizing the dispute resolved in foreign countries, international arbitration. So this is another important matter that we need always to consider while we talk about enforcement of the arbitral award. As a summary of this discussion today's my presentation, I would like to summarize in this way. International arbitration, even domestic arbitration is complicated, but international arbitration is more complex in terms of understanding the environment, the context, understanding the law, how they have been defined and explained, and how their respective Supreme Court has explained, clarified the application of the provision in the law. That understanding of that become essential, as well as the culture also matters in international dispute. So this thing I think we need to think over based on this today's discussion and presentation. Identification and selection of arbitrator for international arbitration as international arbitration is a difficult task for many of us. So in this process also, the forum like institution like SARCO can contribute and start thinking over this identification and facilitating identification and selection of the quality arbitrators. The fairness and integrity of the arbitrator, it seems very abstract, and we all feel that we do fair decision and we do have integrity, but sometimes and many times this type of question we see that has been arised. Preventing conflict of interest. I think this is the sole matter of the arbitrator. The arbitrator should declare and decide whether the conflict of interest is associated in this matter of arbitration referred to me or not, whether I should accept this case or not for decision making. So this is very crucial, and I think this is the sole matter of the arbitrator. So arbitrator's quality and integrity matters a lot. Time and cost consideration, we discuss a lot. Enforcement of arbitral award, again, we need to think over this. We already discussed. Use of technology, we already discussed. And the other major part is that result-oriented networking. We do have this type of linkages and relationship. And see, this is one of the result-oriented networking. With SARCO, I believe that we conduct this type of webinar to develop our ADR environment, to clarify, to understand our different perspectives. So this is again a good initiative of SARCO and use of feedback and learning from the experiences. But again, we need to consider that this is a confidential nature of the disputes referred for arbitration. And capacity building, indeed, we talked as a national, regional, and at international level. These are essential. So to conclude my presentation, I would like to say that just before I talk about, I summarize those things. from my presentation, and this is my concluding saying that before you that let's try making ADR faster, cheaper, and credible. Let's help updating legal framework capable of addressing international, regional, cross-border commercial dispute settlement and arbitration. Let's work for building effective collaboration among SAARC ADR institutions for mutual benefit. Let's realize that the emerging technology is to assist, not to replace ADR professionals and practitioners. And let's start enhancing and strengthening capacity from individual to institutional level. So, working together will help strengthening and supporting each other. There is no competition between you and me. I think this is what another thing we need to think over. We usually just indulge in competing with the nearest one. This is not the this is not the demand of this time. This is that we need to develop our competency and our quality. The challenge is to prove that individual competency, trustworthiness, and high moral integrity in overall dispute resolution and arbitration processes. This is my concluding remarks. These are some of the resources that I refer to while preparing this thing. So with this, again, thank you, SARCO, the Director General, and the Sakibji for giving NEPCA and me this opportunity and just choosing Nepal for this presentation. Thank you so much. Thank you very much for all your patience. Thank you.
Thank you, sir. I'm just joining through a different device because my internet was not working on my other laptop. But very thank you for your comprehensive remarks and your insights on the ADR framework and how it is developed through the years. I really like the way you taught about the history of the different institutions which developed and which are now in one of the leading institutions in our Asian region. For example, the HKIAC or the DIAC, these are the more well-known ones. And there has been a number of developments. It's very obvious that ADR has gone paces since it's developed first. I am also very interested by the fact that there's been a lot of development from the Indian side, and a lot of the examples that you shared with us were that how Indian law has developed and been able to promote ADR, which in turn has then helped the SAARC region pick and choose the developments. So before I open the floor for question and answers, and to all the audience members, please share your questions in the chat box. I have one question. So from an AI and a digital perspective, what kind of developments has Nepal taken or is in the process of taking so that it is on pace or on track with implementing those measures so that any processes of arbitration, mediation, or award writing, anything like that, is done in a more regulated manner?
Thank you, Sakibji, very time for this very timely questions. Recently, that AI policy has been just approved by the government. So other thing has not been started. And in terms of ADR, that we have not yet initiated this type of thing. There's working as ODR, online dispute resolution platform, or using AI for assisting this arbitration procedure. But we have started discussion in this thing now, in this matter.
Okay, thank you. So we have our first question from Mr. Satya Narayan Shah. Let me first thank first of all, thank Dr. Adhikari for wonderful database presentation. My query is, you named few of the good performing institutions in the arbitration. Why and where do we lag behind in comparison with others?
Where we are lagging behind? Is that the question?
Yeah, where we are lagging behind in comparison with the better performing ones.
Yes, basically, this is in terms of the government institutions, the government facilitation and framing the laws that updating the Arbitration Act to provide this type of environment. If we compare with the SIAC or Hong Kong International Arbitration Center or even Dubai. So this is the major thing, the updating. And the second is that the competency and the standard of particular arbitrators and our various these professionals who are working in this field. So basically, this is the capacity development part. I think this is the major gap in this, the understanding at the government level.
Thank you, Dr. Adhikari. Another question is that, in your opinion, how does the current legal framework of Nepal fare against the rest of the SAARC countries? So, in your view, where would you rank yourself amongst the 7-8 SAARC countries?
So I think just making this presentation and being a chairperson of NEPCA, it is not good. No, the conflict of interest part we just discussed. So I must answer this as a tricky answer. No, the Nepal has framed and practicing this arbitration, as just I mentioned you, for over 6 decades. So we do have a strong legal background, but it is not clear. That is the major lacking. No, it is not clear about adequately clear about what is international arbitration and what is domestic arbitration. So this is the major lacking, and in this setting, if I would say we are not in good position. So we need a timely amendment in terms of various other matters. So it is not the comparative thing, but to realize that we need a good amendment in our prevailing Arbitration Act. Thank you for this question again.
Thank you. So we have another question from Dhruba Podial. So South Asia being an emerging region in the area of development of infrastructure and other commercial activities, however, the region is not keen to make an effort to collaboratively enhance the capacity regionally. Your opinion, please.
Thank you again. So I think that this is something different, because the collaboration with our regional institutions that is becoming more prominent and more strong these days, and this is realized and realizing. So there are many activities going on related to ADR and dispute resolution type of thing, and our many practitioners, our many other arbitrators and councils are participating in those events and activities, and they are also representing in various foreign cases. So recently I was in Islamabad. No, there was a big event. It's Pakistan International Dispute Weekend. So I saw their participation from many different countries, and their perspective is there. So again, there are many things that still we need to do in this part, in this thing, and for making a very effective collaboration.
True. I'll just add to that this event is a very good example of the collaboration within the South Asian region. And not only SARCO is here with NEPCA, there is also IMAC, there's also Mr. Rajapakse from Sri Lanka. And so a lot of people joined us during our webinars from different nationalities. So we are promoting that. I mean, it's a slow process at the end of the day, but there are steps being taken. So another question, Dr. Adhikari, from Advocate Sharan Shankar Paudil. Thank you so much for your excellent presentation. I would like to put forward a question. What role can NEPCA play in promoting Nepal as a regional hub for ADR through online dispute resolution in South Asia? And how can it be improved to meet modern technological challenges? So, sir, how can we further improve NEPCA?
Yes, sir. We are improving. So we have created our platform that we can have online presentation and online all dispute resolution process online. So only the thing is that, as I just mentioned, that some clarity that we need for them related to what is international arbitration and what is domestic arbitration, some recognition of this online or use of a virtual platform. That is what another thing is essential. And we are ready to have these all technology with the NEPCA along with the part backed up by parties' interest. No, until and unless the parties are ready for that, and therefore we have started saying that why NEPCA and Nepal Kathmandu cannot be a venue and place for arbitration, no, as a neutral venue for our region. So this is the thing, and with this vision that we have started discussion and we're working for this.
Definitely, sir. And I think we will also, from SARCO's perspective, we will do whatever we can to strengthen our national institutions as well. And hopefully Nepal can be also one of the more prominent locations in our area, because sending cases to Dubai or to Singapore, it just adds to the cost. I mean, people always prefer these as the, the prime locations or the main ones to go to. But what they don't realize is that this increases your cost substantially.
Thank you so much for this. Thank you.
Yeah. So another question from Khurram Saab from Ministry of Law and Justice. Khurram Saab, if you're with us, I would like to have you on screen, sir, if you're not busy. Otherwise, I'll just read your question. Let me see if Khurram Saab is available. I think he's a bit busy. So I'll just read the question. Do the arbitrator has any power to impose any kind of financial or other penalty on the party, especially on the respondent who delays the proceedings unnecessarily? And what are your recommendations for an expeditious arbitral proceedings?
Oh, no, not yet. I think that the arbitrator can impose an additional thing because this is a very much complicated matter. The arbitrator are nominated by the respective parties, and the nominated arbitrators will appoint the third presiding arbitrator. So this is somehow delicate type of thing, so need to handle effectively. If take example from Nepal, so recently realizing this thing, the government had amended the Arbitration Act and said that the government public entity should not delay the arbitral proceedings. No, if it is found the relevant staff, the concerned staff, authority or the officer will be penalized. So something this is to strengthen the implementation of this decision of the arbitration. So I think this need good discussions and need to influence the court and the government for framing the right rule, no, right law. Otherwise, the probing agencies, oversight agencies, there will be no answer to oversight agencies from the arbitrator side. No, if this type of decision is started making. So this is the complicated thing, I think, in this regard. Thank you.
And so secondly, what are your recommendations for an expeditious arbitral proceedings? Like how can we fasten them? I mean, in your examples, there were arbitrations which are over 400 days, So how can we make them more faster?
Yes, I think if this type of thing, if the party, the other, basically the claimant come to seeking decision award on time because the claimant think that the claimant is suffering. In that case, in the absence of respondent's support, the claimant is required to deposit. In case if it is not in time, then allow the claimant to deposit this type of thing through the law, no, or legal provision, so that the claimant will deposit, and that deposit part will be decided by the arbitrator, that who will be whether respondent has to pay that amount along with interest, and that has to be enforced by the court, no, in such situation. So if this type of thing is there incorporated in the Arbitration Act, then this will help expediting the arbitration procedure, I think.
Thank you, sir. Before I move to the last query, Khurram Saab, would you like to say any words? Sir, you're muted.
Yeah, thank you very much. And Thanks a lot for giving me the chance. And thank you, Dr. Saab. Thank you, Dr. Adhikari. You have given a very good presentation, very detailed presentation. And the way you have explained everything, the history of the arbitration in different jurisdictions, in the domestic level and in the international level was very good. I really appreciate that. And yeah, well, I wasn't here when my questions. I've already posted my questions there, and I think you have already replied to those questions. Uh, so, sir, I was thinking that you have already made the suggestions that how we can make the entire process expeditious. So that is very good. But how do you see that, in other jurisdictions, how do you see that which is the model arbitration law which has to be followed? Because Pakistan is also in the process of making, a lot of amendments, or in fact, making a new arbitration act is under process. So, do you suggest any things from your experience that these kind of provisions should be added, which are not there? I mean, which you feel that is already there in Nepal, and which can make the entire process more expeditious and more effective for both parties, or for the entire proceedings, take place in an expeditious manner. What are your comments on this, sir?
Thank you, sir. Thank you. This is indeed good and very difficult questions to answer, because it need some review of arbitration law in Islam. But I heard that while I was there I was there recently. Some arbitration act has been drafted, and we're waiting for enactment. Something like is there. But in general, no, the SISC, Singapore International Arbitration Act, Singapore Act, and Hong Kong Act, I think they are more proactive to address the need of the time. And definitely, again, we need to tailor them and translate them into our own requirement. No, as I mentioned earlier, that the culture part and the socio-economic development part play a very important role in implementation and enforcement of the Act. So many things as they envisage may not be applicable for us. But in terms of use of these AI facilities, if it is there, then as I just mentioned, the availability of that platform and familiarity with all these things is immediately required with our all professionals working in this field. So these are interlinked. No? So some sort of transition is required while implementing those things. But I prefer this SISC and Singapore and Hong Kong Arbitration Act to refer in this matter. Thank you, sir.
Thank you, sir. Just one more thing, sir. Do you recommend that these acts do not empower the arbitrator to impose any kind of penalty? Do you think that there has to be such kind of a provision in which the arbitrator is authorized to levy some kind of penalty on the party which is delaying the process unnecessarily? Do you think would be appropriate? Or do you think it is going to make it more cumbersome, or it is going to delay the entire process? What is your recommendation, sir?
There was some echo while you were speaking. So I think, could you briefly just summarize your questions once again, sir?
Yes, sir. I briefly summarize. I just wanted to know your opinion that do you think any provision should be added in the Arbitration Act which empowers the arbitrator to impose
regarding the fee, arbitration fees? I think this was your questions.
I think Khurram Saab has dropped off a bit. We'll just wait for him to come. In the meanwhile, I can possibly answer the query which was referred to me. So, what is the level of usages of AI in arbitration proceedings in your country? Satyanarayanji, at an official or a legislative level, there's no such work going on. as to make AI a part of the arbitration laws of Pakistan for now. But AI is being used at a more private level. This all comes down to the integration by the institutions. So some institutions have made their own not semi, but small personalized AI, which helps with their confidentiality matters and very specifically makes it more aligned to what their goals are and what their needs are. But from an official level, there's no as such integration in the laws of Pakistan with regards to AI. I hope that answers your question. Another question till Khurram Saab comes, we can just ask. Question, what practical accreditation and ethics standards should Nepal adopt for mediators and arbitrators? Dr. Adhikari, if you could.
Yes. Okay. For mediator, there is mediation council, and that has said all the thing. They need to register with mediation council, and they conduct trainings to become a mediator. So this is regulated. And for arbitrators, parties' autonomy to nominate arbitrator. However, the institution like NEPCA, I have just already mentioned also in my presentation that we do have different criteria. First, the person need to be life member of Nepal Council of Arbitration, and to become life member of this council, then there are certain criteria. They are available in our website also, and thereby, if they aspire to be enlisted as arbitrator, again, there is a criteria, additional criteria, and fulfillment of those criteria, then they will be enlisted as arbitrator. So that is providing the good list of good or some sort of it is not the legal term accredited, but this is the scrutinized arbitrators are there, and we conduct 5 days training, and to become our member, we ask them to sit in this 5 days training or show the evidence that they have undergone any equivalent training elsewhere. So these are the things in Nepal.
Thank you, sir. I think pretty comprehensive requirements. So I'm not sure if Khurram Saab is joined back.
Khurram sir's question is there in the chat box. I found it.
Okay.
So I will read that, and I try to see if I can answer this. Do the arbitrator has any power to impose any kind of financial or other penalty on the party?
So we went through this, sir. We went through this question. I think he had additional questions. He has just joined the meeting. Let me see if he's available. Otherwise, I can maybe connect you two separately offline, and then he can. So, Khurram Saab, are you with us? I don't think so. I think he's facing internet issues. So just before I move towards the closing remarks, Dr. Adhikari, thank you very much. Would you just like to say any final few words before we conclude our webinar?
So thank you for hosting this webinar again and giving us this opportunity to speak before this August in this August presence. So we will be in touch for more result-oriented and other fruitful activities. So thank you so much, sir. Thank you, SARCO, for this.
Thank you, Dr. Adhikari. It was a pleasure to have you with us once again. And again, it was a very insightful presentation and with very evidence-based, data-driven insights for us, which also help us improve ourselves as well. From the perspective of working together, we will hopefully invite you further towards other events and also connect you with our stakeholders. So Khurram Saab, who I mentioned many times, is actually one of our governing board members, is also part of the Ministry of Law and Justice. So I think he's in the chat. Let me just ask him if he can ask his question here.